Welcome to Dignified Family Transitions with Lilie the Lawyer.
Welcome to Dignified Family Transitions with Lilie the Lawyer. Lilie McRoberts is a Minnesota family law attorney and mediator who helps individuals and families navigate divorce and custody matters with a focus on problem solving, not conflict, and practical, respectful solutions. I'm Shameika Rhymes, and today we're talking about how to prepare for divorce mediation in Minnesota. Welcome back, Lilie.
Hi, I'm so happy to be back, and it's so nice to see you today.
It's great to see you. So, Lilie, to start, can you explain what mediation is in Minnesota family law case?
Sure. So mediation in Minnesota is just one type of what's called alternate dispute resolution, or ADR. And mediation specifically is designed for two parties in a family law dispute to come together to get a sense of what issues they actually are in agreement on and what issues they still need to resolve. So anytime you have a family law case in Minnesota, either to establish custody or to, either to establish custody or to get a divorce, you have a list of things that you are going to have to present to the judge. The first step is going to be putting all the information out there. And then the second step is going to be, how do you want these matters to be resolved? So in divorces, there's property, and then there's custody and parenting time, and maybe child support or spousal support. So there's all these different issues that you are going to have to present to the court. This is what we want to do with these issues. Mediation is the opportunity to, ideally, you'll have already put your discovery together, so you'll already have the information gathering section done before you go to mediation. And then it's just, what do we think about these issues? And what's surprising a lot of times is you actually agree on what you want to have done with each and every one of those issues that the judge will expect for you to resolve in order to close up the case. So that's what mediation is it's really a way for two people to come together and find out what they agree on and find out what they don't agree on with respect to their divorce or their custody case. And that's usually, a lot of times, people find out that they agree on more than they would think, and then they just, come to a resolution. But when there are conflicts, if you want to call it, where they want different things, then mediation is going to be an opportunity for each party to get an idea of, if it's done properly, the mediation is going to be for one party to get an idea of why the other party is coming to that particular issue with the position that they have, and then find the common ground. And there almost always is common ground. So that's really what the mediation is.
Well, why does Minnesota require mediation in contested family law cases?
So that's that's something that a lot of people get really frustrated about until they understand the why behind the mediation. The fact of the matter is that Minnesota does require mediation in almost all instances when you come to court and you have what is called a contested case. And I should define what's contested and what's uncontested. So when people get divorced in Minnesota, or when they decide that they want to, unmarried parents decide they want to have an order deciding parenting time and custody. When they come to that decision, they can bring the entire case before the court as a joint petition with everything resolved. And sometimes you still have to have a hearing, but in those cases, when you come to the court with everything resolved, that's called uncontested. And then you're not required to do mediation. You're only required to do mediation if it's a contested case. Now, there are a few other exceptions to the requirement that you participate in mediation. The other exception has to do with when there's domestic violence. But even then, sometimes mediation can be helpful. It's just the courts aren't going to force the parties to try to come to a resolution. There's lots of different reasons why the courts require it. And ultimately, the biggest reason is because it is always in the children's best interests, and always in the part, even if they don't have children, it's always in the parties' best interests to come to the resolution themselves. They have buy-in, they have far more control than they would have if a judge just ordered what they should do. And in the cases of children, kids pay attention. And when the parents designed the parenting time schedule and when the parents decided together, it's just way better for the kids.
Yeah.
Also, the courts do this because, 95% approximately of the family law cases settle before going to trial. And it's expensive for the parties to do trial, very expensive for the parties to do trial. This is a way to keep them from having to go down that contentious road. Also, it's good for the courts too, because the courts are going to not have to have such a high volume of cases. And so they'll really be able to preserve those judicial resources for the cases where either there's domestic violence or the parties just can't communicate. So those are the reasons why the courts do require mediation in most contested cases in Minnesota.
Well, let's talk about, what does a typical family law case look like in Minnesota?
You've likely just went through a breakup, unfortunately. Yeah. And I always tell my clients, you've already gone through the hardest part by making that decision. Everything else is just paperwork. The typical family law case is going to start with a breakup, usually. And then a decision that you want to have a judge enter some sort of order. It's not mandatory in the cases where you're not married, but if you want to get divorced, you are going to have to get a judge involved in some capacity. Then the decision is, what information do we need to bring to the court? And what with divorces, it's going to be, how do we divide our property? What property we have and how do we divide it? And then with kids, it's going to be, how do we set forth a parenting time schedule that looks best? And then you figure out if you can agree. You go to either you hire an attorney or you go to the self-help forums, and that's how you decide what form to fill out. Now, I do have in a previous video, I did break down the different form types that you need, so I don't need to go into that again. But you're going to decide whether or not you're going to be filing jointly or non-jointly. It's super easy if you're filing jointly. In certain case types, you have to see a judge. You have to have what's called a default hearing, even if you're in agreement. Then the judge is going to look at your agreement, and the judge is going to decide whether or not to sign off on it, maybe have a hearing. And then once that's final, then the judge signs the divorce decree. Then you're divorced, and then there's paperwork that you have to file. And if you have to have a name change, then you're going to get that name change. Hopefully I'll have future videos on how to do all of that. And all of those resources are available online. And sometimes you have to record things with the county recorder's office. When it's contested, you are going to file. That means that you're going to be filing a petition, or you maybe received a petition and then you have to file an answer. The court is going to schedule in Minnesota, in most counties, an initial case management conference hearing. And that's just going to be the opportunity for the court to tell you you should mediate, give you an idea of what the process is, but no decisions are going to be made at the ICMC hearing. While you're getting that ICMC hearing scheduled, ideally, you will be working on scheduling an appointment with a mediator because the court is likely going to tell you that you have to mediate. And the sooner you get it on the calendar, the better. So that's going to be where you go to. There's a website that the court actually gives you where you can get qualified neutral mediators. And I can also give you a link to that. So then you're going to pick a mediator, and then you're going to, at that hearing, the court will schedule a review hearing. So between the ICMC hearing and the review hearing, this is where you're really going to work hard on figuring out what it is that you don't agree on and try to find that common ground. At the review hearing, the judge is going to find out whether or not you think that you've settled the case, or if you think you're going to be settling the case. And then the judge will decide whether or not to schedule the case for trial. The trial is where there's a fact finder that tells you what your divorce is going to look like, where you lose the control, because the judge is going to be the fact finder, and the judge is going to tell you how your property is going to be divided. And then the judge is going to tell you, if you have kids, who gets legal custody and who gets physical custody, and what the parenting time schedule is going to look like. And anything that you haven't agreed on, the judge will order at the trial. There's also a discovery that needs to be sent while you're leading up to trial. And that's, statements and all the information that each party is entitled to. So that's beginning to end how each of those case types track.
Okay. Thank you for breaking that down for both sides. And I love what you said about, you've already been through the hardest part, which was making the decision to break up, which, yeah, in my head, I could just picture people, like you see on the movies, you're eating the ice cream, you're sad. And then it's like, okay, now let me go handle the paperwork stuff.
I have a joke that I used to say, like, I say all my clients are superheroes. You do all the hard work, and I'm the one, and you strike your superhero pose, and I'm the one in the background doing the paperwork for you.
Oh, I love it. Well, what information does a mediator need from someone that's going into mediation?
Yeah, so we touched on this just a little bit, of course, but to break it down, that's something that, you're going to be selecting a mediator in your case, and you are going to be paying that mediator. And I do dance with my husband, and we have weekly dance sessions, and it's so wonderful. And I love that we at least have that. But then at the end of every single dance session, my dance instructor gives me a video, and he gives me all the work that I need to do until, practice every single day till the next dance session. And I keep on telling myself that I'm going to be doing that, but, life gets busy. Right. And so then I go to the next dance session, and I'm really grateful that I have that dance session, and it's always on my calendar, and that's me time with my husband. But I always think to myself, well, I'm paying for this dance lesson, and I would be getting so much more out of the money that I'm investing if I were actually doing the practice every single day, which I never do, but I should. So that pairs with the mediation. So you're paying the mediator. And not all mediators give you a list of everything that they want. Some mediators allow you to upload paperwork that's been filed into the case. And some mediators really prefer to not necessarily read all the documents because they want to get a sense of the people, real time. However, the more information that you have gathered, especially with a divorce, because with a divorce, you need, in order to actually get the divorce, you have to list out all the property that you have, all the assets that you have. And then your attorneys will be doing a balance sheet to equalize that property division, for at least for the stuff that properly you can identify the fair market value on, or come to an agreement on the fair market value. So there's property, and then there's also information on the children. The more that you can have available to you before the mediation, the more you'll have a sense of what even needs to be decided before the mediation. So in a perfect world, you'll have a bank account statement, or at least a balance of every single statement. Ideally, those statement account balances will be Ideally, those statement accounts balances will be from the same or approximately the same date. Finding out how much money you have in each one of those accounts, and opposing party finding out how much that person has in all of those accounts. Then you want the tax returns for the last couple of years. And then you want, if you own property, you really need to get a copy of your deed, because no matter what happens with the divorce, the title search is going to have to change because you're going from being married to being single. And so then, in order to properly record any change in a title of a property with the county recorder's office, they need to have the full legal description, which is just, people's eyes start glazing over at this point. What do you mean legal description? Why can't I just have the address? But that's just one thing that ideally you'll have that. It's not necessary to have that for the mediation, but it's just nice to have that ready to go, because sometimes with mediation, you can leave that mediation with what's called a mediated settlement agreement, where you can actually take that settlement agreement to an attorney, or even file it on your own with, you need to file additional paperwork. But if your mediation goes very well, and you've already filed the paperwork for your divorce, you can actually file that mediated settlement agreement in, and then have a default hearing, and the court that could be the divorce. Or you can take it to an attorney, and they can draft the paperwork for you. So it's really good to have that legal description. It's really good to have, people don't think about this, but it's not a bad idea to have a picture of your children. And some judges actually like that picture of the children filed when they file that initial case management hearing, so that the judges can see. But mediators really like to be able to see these things. So that's a really nice touch if you add that to your mediation materials. And the detail, be prepared to talk about your kids. And the first part of mediation, really, for any mediator, is going to be the mediator gathering that information. So the more that you give them ahead of time, the more efficient they'll be able to use their time.
Well, Lilie, this has been so informative. Thank you for breaking down what you should know about mediation today.
Yeah, absolutely. I'm glad to. It's great.
That's it for today's episode of Dignified Family Transitions with Lilie the Lawyer. If you're preparing for a divorce or a custody matter in Minnesota and want a more thoughtful, problem-solving approach, you can learn more about Lilie McRoberts and her work at minnesotasfamilyattorney.com. Thanks for listening, and be sure to like, leave a review, and subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.